Okay, good morning, everyone, or good afternoon, whichever part of the country that you're in. I'd like to welcome you to our Gowling WLG seminar on special committees. We appreciate all that are attending this webinar today, and we hope you find the webinar beneficial and informative. We have with us today two seasoned practitioners and a highly qualified industry panelist who will cover our topic today. I'd like to mention that this webinar is the first of a three-part series of webinars provided by our Gowling's National Governance and Activism and Investigation Group. This webinar will cover, as we said, the governance topic of special committees. We're going to have a second webinar later in the summer, and it will cover the activist topic of trends in shareholder activism. We're going to have a third webinar, which will be in the fall, and it will cover the topic of investigations related to shareholders and boards. Just a few housekeeping items. First, because this presentation is being put on by lawyers, we would be remiss if we didn't also include a disclaimer. So today's session will be a high-level overview for a general informative purposes only and does not constitute legal advice. For specific advice relating to the topics discussed today, you should consult with legal counsel. And information in this presentation reflects the laws and other relevant standards that are in effect as of the date of the presentation. So let's turn to our agenda for this hour. Today, our panel will be covering 5 main topics. Number 1, what is a special committee and how does it differ from the other board committees? Our second topic will be related to special committee members and their responsibilities. Our third topic will be the special committee relationship with management and with the board. We'll discuss the role of special committee advisors, and we'll finish with governance tips or best practices for special committees. We anticipate many of you will have questions, and your questions are important. So if you have a question, please use the button labeled Q&A at the bottom of your screen to submit your questions. We'll do our best to answer your questions towards the end of the session, but feel free to reach out to our team members afterwards as well. And this presentation is also being recorded and it will be posted on our website in a few days, so you can always visit our website and get a full recording of this session. So now to our panel. We have with us today, as I indicated, 2 seasoned practitioners. We have Kathleen Ritchie and Cindy Lavelle from our Gowling WLG offices. And we have Cam Crawford from the Catalyst Group. Kathleen Ritchie is a partner with our Gowling's Toronto office, and she is the head of our Toronto office business law group. Kathleen is also a past leader of our firm's corporate finance, M&A, and private equity group, and she served as legal counsel to many special committees. We have Cindy Lavelle, who's a partner with our Gowling's Vancouver office. She's also the past leader of our firm's National Corporate Finance, M&A, and Private Equity Group, as well as the past co-leader of our firm's mining group. And Cindy has also served as legal counsel to many special committees. We're privileged to have Cam Crawford with us, who is a financial professional who spent the majority of his career as a partner with the Catalyst Group, serving as managing partner at Catalyst and on the boards of Catalyst's North American and international affiliates. Cam's also had numerous public, private, and nonprofit board positions, including he acted as chair of the Special Committee of Rocky Mountain Dealership, Inc., which I had the privilege of being counsel to that special committee. My name is Greg Peterson. I'm a partner with the Gowling Calgary office, and I'm the head of the Calgary office corporate finance and private equity group, and I'm also the co-leader of our National Governance and Activism and Investigation Group, and I will be the moderator of the webinar. So, to get into our presentation, I'd like to start our discussion today with the comment that in today's corporate world, the directors are being scrutinized really now more than ever before. And as a result of this intense scrutiny, boards of directors are using special committees more and more to evidence that the directors are satisfying their fiduciary duties. So to start off, Cindy, I'd like to ask you, can you explain what a special committee is and how it differs from the other board committees that we're so familiar with, such as the Audit Committee, the Compensation Committee, and the Governance Committee, and all the other committees? So Cindy?
Sure. Yeah, sure. Thanks, Greg, and welcome everyone. So the typical committees that we hear about, like you mentioned, the audit committee, governance committee, health and safety committee, those are what we refer to as standing committees. And those are established by companies for ongoing matters, such as the audit and addressing compensation issues. Special committees are established on an ad hoc basis, and they're established to deal with a particular issue or a situation that's developed in a company. Both types of committees are typically a subcommittee of a board. However, unlike a standing committee, a special committee is formed for a specific and time-limited purpose. So I'm sure most of our viewers today are very familiar with the establishment of special committees in the context of M&A transactions. Well, special committees can extend beyond M&A matters. And certainly last year, we saw many special committees being formed to deal with governance issues related to reporting and addressing the COVID pandemic. We see special committees being struck increasingly more to deal with risk mitigation and other special situations such as shareholder activism. It's important to remember that whatever purpose a special committee is struck for, it's really a critical tool in ensuring that boards fulfill their legal and fiduciary duties and mitigate litigation and other risks in certain very high stake matters.
Okay, thanks, Cindy, for that insight. So Kathleen, why don't you talk a little bit about when should a special committee be established, and what exactly its role or purpose is?
Well, thanks, Greg. So really, interestingly, with one exception, there's no legal requirement to establish a special committee in Canada. We do have a requirement under Canadian securities laws, more specifically under the Canadian Securities Administrators Multilateral Instrument 61-101, which relates to the protection of minority security holders in special transactions. And they require the formation of a special independent committee in just one scenario, and that is in the context of an insider bid. An insider bid is a takeover bid which is done by an insider. So this is, not the circumstance of an arrangement or another transaction that's implemented by a shareholder vote. But that said, according to staff notices by the CSA 61-302, the staff are of the view that a special committee is advisable in all material conflict of interest transactions. So that means other transactions that are under MI 61-101, business combinations, related party transactions. So why is this? Well, I think they think that a properly constituted special committee with a robust mandate can ensure that the interests of minority security holders are appropriately taken into account, and then thereby alleviating the conflicts that underlie material conflict of interest transactions. The view of the staff is that active engagement by a special committee in the process, free from interference, undue influence by persons with a conflict, this assists issuers in complying with 61-101. And obviously this then mitigates issues around public interest concerns. I would add that a properly constituted special committee following a proper process should also reduce the risk of a transaction being subject to complaint by a securities regulatory authority, and the likelihood of the CSA staff raising procedural issues when reviewing a transaction. And the reason that I raise this is because they are reviewing the transactions. Every time an issuer files a circular on CDAR, in connection with a transaction, the regulators are looking at those circulars, and they're looking to see what the process has been that the company has followed. So in any event, whether it's required by law or not, striking a special committee is more widely considered a best practice, can provide a significant degree of protection to a board, and it can help mitigate the concerns around conflicts of interest. Further to what Cindy mentioned, other instances pre-COVID where we've been involved in board striking special committees as a governance best practice, things like significant litigation or regulatory proceedings, really anything that is highly confidential, sensitive internal investigations, and as Cindy mentioned, shareholder activism matters. So the idea is that you form the special committee to ensure that the board's consideration is not influenced by parties who might be interested. It's also to ensure that you've got a group of people who aren't distracted in their deliberations, by interests of other parties. And it helps you demonstrate that you follow an appropriate process. Establishing the committee is just the first step, though. We've got case law out there, the OC's decision in the Catalyst Capital Group, different from Cam's group, Hudson's Bay Company, where a special committee was established, as an appropriate protective mechanism. The commission's very clear that the processes are key. So you've got to make sure that you've disclosed those processes as well. I mean, the point is that establishing the special committee is not just for show. In that particular case, the OSC held that regardless of the fact that HBC didn't need to have a special committee, it wasn't required under law, the fact that once it did establish it, it would be held to the same kinds of standards as a special committee struck for purposes of an insider bid under 61-101. So, if a company does embark on this process, in terms of its purpose, you've got to make sure that it fulfills those requirements, regardless of whether the law requires it to do so or not. And I'll just finish, Greg, with a comment that there are a number of additions for a well-run special committee. The robust mandate, the engagement of independent advisors, supervising, or directing the conduct of negotiations, accurate record keeping, all of these things which we're going to discuss further in the session.
Okay, thank you very much, Kathleen. So Cam, from your experience as a special committee chair, what advice would you provide a potential special committee member as to what to expect going into this process?
Yeah, thanks, Greg. And hello, everyone. Great to be with you today. When I was involved in our special committee process with Rocky, I had occasion to try to explain to my 6-year-old granddaughter what I was doing, why I was so busy. And I told her we were trying to make a plan for a difficult situation. And as only a 6-year-old could, she tilted her head to the side and said, "Well, Grandpa, why don't you just plan to go to Disneyland?" So I'm sure you'll get lots of better pieces of advice today, but that's certainly one of them. So this recent situation that I was involved in, we set up a special committee on 3 different occasions over 18 months. Each iteration of the special committee was precipitated by a go private proposal from insiders. So that's my body of work on special committees. I've been a chair of a special committee 3 times. Generally, I've had lots of experience with other dimensions of governance in various other circumstances and situations. And having spent the majority of my career advising clients on business strategies involving complex matters, I drew heavily on that experience. And as well, we'll touch on it a number of times, just that hard-earned professional judgment. So as has already been said, special committees by their nature are struck to deal with complex issues. And I think it's really important to recognize different dimensions, certainly of a transaction-based issue like we dealt with. And I like to lump them into 2 broad categories. Things tend to either fall into the art of the deal or the science of the deal. And I'll come back to that a couple of times in my comments here today. So my first takeaway for a potential special committee member would be to make sure that you have really high comfort in your business judgment capability, and more importantly, you're prepared to use it. There'll be very little time and opportunity for ambivalence or indecision, no hand wringing or dithering, as they say, that just won't fly. I'd be remiss if I didn't do an unpaid endorsement for the Institute of Corporate Directors Education Program. While the topic of special committees specifically was a relatively minor area in the ICD curriculum, I drew heavily on the program's content on overall approach to good governance and good judgment principles. So highly recommend the ICD program. The special committee learning curve is steep and fast, involving a major time commitment to understand the process. And again, here we're back to the science of the deal, and then to get deep into the details of, in our case, a proposed transaction. And again, I describe that as the art of the deal. So the pace of play is very rapid. there won't be too many times to say, well, no problem, we'll deal with this next week. It'll be quick turnaround required on many, many complex issues. We probably came close to about 80 meetings all in over the course of our 18-month special committee experience. Many were scheduled, but many were called on just a few hours notice. So I guess that would be my next takeaway. Be prepared for an intense, rapid fire and time-consuming process. Personally, I'm in a transition phase in my career, doing less work in my firm. So I guess that helped me better to be able to keep up. I can't imagine dealing with that special committee chair role if I was still working full time. So for my final takeaway as regards what to expect, I touched back on the science of the deal. And already, for example, 6101 has been mentioned and likely be mentioned a couple of more times. But the good news is the likes of 6101 is obviously a very detailed and comprehensive blueprint, and it's a good guide. The bad news is the likes of 61101 are very detailed, comprehensive blueprints that must be followed. So that knife cuts both ways. As I think we would all be aware and know, many good public domain sources of information out there on special committees, professional associations, individual firms, all that information can greatly assist with the learning curve. Obviously, just be careful about placing undue reliance on general information. So in conclusion, understanding the critical workings of rules like 6101, having an excellent understanding of corporate fiduciary duties generally, these are must-have for special committee members, and then building those understandings into your detailed special committee blueprint and playbook are essential.
Okay, thank you very much, Cam. So Kathleen, I'll ask you, who can and should serve as a special committee member, or in other words, what should be the composition of a special committee?
Thanks, Greg. And maybe before I answer that question, I see that we do have a question online. We've got, are there any legal differences between public and private corporations with regards to committees? And I'll just take a quick crack at that one because I think it's relevant to a lot of the comments that we're making right now. You know, the corporate law applies equivalently to both public and private corporations. So the fiduciary duties, which we're going to talk a little bit more about, those apply across both. When we're talking about 61101 and what the CSA staff is speaking to, that's focused obviously on public companies. So I just wanted to make that distinction for our audience. But obviously, you know, from the perspective of the securities regulators, you know, not surprisingly, they're of the view that the composition of the special committee impacts its effectiveness. And my favorite sort of saying from the TSXV Rules and Tools program, which we've all done over the years, and this is a program on governance and directors, is that there should be no dead fish. And so really a lot goes into selecting the right people to serve both on a board, but specifically on a special committee. So you might have the special committee invite non-independent board members, other people with special knowledge to meet with them, to provide information, to carry out instructions from the committee. You know, the first rule is that there shouldn't be any non-independent people on the board. On the committee that are participating in the decision-making deliberations of the committee. You know, there may be limited circumstances, and you know, the question was asked about the private context where maybe the committee is not composed entirely of independent directors. But you know, if you're going to take that kind of a decision, I think you want to look at getting legal advice in that circumstance. And obviously, in the context of a material conflict of interest transaction, it would be very rare to have non-independent directors on the committee. And in fact, the CSA staff, you know, when they do these reviews, they're going to consider whether the members of the special committee are independent within the meaning of MI 61101. And they want to see a special committee conducting itself independently, being given the authority and opportunity to discharge its mandate independently, you know, without the influence from interested parties, you know, who involved in the transaction. And another aspect to consider is just what's the size of the committee. And this is obviously driven by various factors, but you know, you want it to be a pretty small group of people who can act very quickly and focus on the matter under consideration. You're trying to get a group of 6, 7, 8 people together for CAM's 100 meetings, like that's just not going to happen easily. And it's a lot of resources. So you want to make it small. And finally, you're looking for people with the requisite skills and experiences. So people who have served on special committees beforehand, who have particular expertise for the nature of what the committee is considering. So if it's M&A, have been through M&A context previously, know something about the industry, something just more than your average board individual. I think the last piece, to Cam's point about the number of meetings, like they've got to have the time to devote to the committee as well. So it would be very challenging for people who have sort of full-time management roles, say at another company, to participate in a special committee process.
Okay, thank you very much, Kathleen. So you've taken into consideration Cam's points. They've decided to form a special committee. You've got the special committee members. So I'll ask you now, Kathleen, what are the duties and the powers of the committee members, and also maybe talk a little bit about the chair of the special committee.
Okay, I think you meant that question for me.
Sorry, I said Cindy, didn't I?
That's no problem. That's no problem. So, Kathleen's touched on this a little bit when she was talking about sort of the difference between public and private corporations. So the duties of committee members mirror the fiduciary duties and the duty of care obligations imposed under corporate law on directors generally. The duty to act honestly and in good faith with a view to the best interest of the corporation. In the context of an M&A transaction, the board is really charged with considering the interests of the corporation as a whole and all of its stakeholders. And so on special committees, members need to evaluate the discharge of their duties. The same considerations would typically apply as would apply in respect of any directors. And that's why it's important to have a well-drafted mandate. I know we've touched a little bit on the mandate, a couple of things. So, what's the mandate? So the mandate's really the committee's backbone. And it's a written document. It's generally approved by the full board, and it sets out the committee's purpose, scope, duties, and powers. And the mandate is generally tailored to the specific situation that the committee's been struck to address, or the relevant transaction. But it's critical that the mandate is broad. If a special committee's mandate is too narrow, the courts or regulators may question the committee's efficacy. Yet the mandate needs to be sufficiently precise so that the committee's both empowered and accountable. So some of the things, and I'm just going to read this because it's taken from Staff Notice 6132, which we touched on a bit. So in the transactional context, this is certainly what we would from experience expect, and certainly what the regulators expect. So the mandate, it's expected that it would empower the committee to negotiate or supervise the negotiation of a proposed transaction, rather than simply review and consider it. The expectation is that the mandate would empower the committee to consider alternatives, the transaction that may be available to enhance value. And that includes maintaining the status quo. It should require the committee to make a recommendation regarding the proposed transaction, either to the board or to the shareholders, or if it does not provide detail reasons why not. And it should allow the committee to engage its own independent legal and financial advisors without any involvement of interference from interested parties or their representatives. And there's other things that should also be included in a mandate. It should speak to the deliverables expected from the committee, its reporting and record keeping obligations, and what decisions it can make versus what must be presented to the full board. And more commonly, special committees are charged with making a recommendation on a transaction to the full board, and the full board has ultimate approval authority. So now let's talk a little bit about So this gets back to what Cam talked about earlier, really about the importance of a robust process. Generally, members of special committees will be seen as taking steps to discharge their duties if they act free from conflict. They retain appropriate legal counsel, they take sufficient time to address the matters before them, and they participate in the process rather than passively receiving information. And so when you talk about the duties of a special committee, you can't forget that the special committee is really running a process. And Canadian courts typically show deference to the business judgment of directors, provided the decision is made following a proper process. The decision doesn't have to be right, but courts will typically not second guess the decision, provided it's been made honestly, prudently, in good faith, and on reasonable and rational grounds. So process is paramount, and I know Kathleen's touched on this. And again, it's process and substance. It's not just form. And boards need to realize that the existence of a special committee will not automatically protect the board against an otherwise faulty or flawed process. So the decisions of a special committee will be judged in hindsight with reference to its mandate, including whether the scope was appropriate and whether the special committee discharged the duties and exercised the powers given to it. And again, I know Kathleen's touched on this, but this is not a rubber stamping type of game.
Okay, thank you very much, Cindy. So Cam, I'll ask you then, for the special committee that you served as chair, who did you select as your special committees, and what advice can you give as to the appropriate number for a special committee, or who would you select?
Yeah, I guess like so many of these special committee questions, the answer to that one, who and how many members, is it depends. I mean, obviously a smaller committee might be more nimble, but the challenge of keeping other independent directors informed in particular would be greater, of course. A larger special committee might be more cumbersome, but with all independent directors involved, communication and decision-making, et cetera, would certainly be much more efficient. And we've touched on it already, but equally, if not more important, is the skill set and capacity of those members when considering the makeup. Like the board itself, good cross-section of experience and expertise, and then special committee members prepared to commit the time, effort, and intelligence necessary to effectively deal with the substance of the mandate. In our case, we had a full board of 8, so we had 3 insiders and 5 independents. There's no doubt in my mind we made the right decision to include all independents on the special committee. And then just looking for attributes of special committee members, again, and it's a fundamental board requirement as well, but just have the willingness to engage in robust debate on issues. And, this is as I say, a general board participation prerequisite, but I think the importance is magnified in the case of the special committee. It's kind of the old story, if all members of a group always agree, then all but one of them are dispensable. And so you don't want to get to that landing. There should be disagreements, there should be healthy debate, there should be healthy tension, but there also must be a willingness to build consensus, to come to conclusions, most importantly, and then support group decisions as the committee goes forward. In our case, I just can't say enough about the quality of my fellow board members on the special committee. They were excellent. We got along very well, had that healthy, robust debate and sometimes disagreement, but we always seem to find our way back to center. And in addition to the general special committee duties that each member had, they each took up individual tasks in their areas of expertise, and we did that on a return and report to the committee basis. So that was very effective to delegate some of the items off to basically the individual committee members. So I've got a great deal of respect for my fellow board members had going into this special committee process, and I have even more respect coming out of it. So it was a very good process for us.
Okay, thanks, Cam. And I know myself as legal counsel to the Rocky Special Committee, it was a huge advantage for myself as legal counsel to have that expertise on the special committee that I could converse with. I know it made the whole process a lot better. So Kathleen, I'll ask you, what should be the proper relationship and communication between, I guess, the special committee and the board, and also the special committee and management, because it can get very touchy on that communication and relationship.
Sure, Greg. Well, so obviously the special committee is a committee of the board, you know, and as Cindy pointed out, most of the time its job is to make recommendations to the full board. So you're going to make a presentation to the full board. Sometimes this is done periodically. It just depends on how long the process is. So you might have an interim report, you might have a number of updates through a process, but at the end of the day, when you have a final set of recommendations, you want to give a full report to the board on the deliberations that you've had, the information that you've received, and how you sort of arrived at those conclusions. You know, I've seen circumstances where the special committee has written an actual report that is given to the board and appended to the minutes of that meeting. It's not required, but it can be helpful in situations. You know, particularly when you then get down the road to having to make disclosures about things, you know, in a circular, if you're dealing with a transaction. You know, when these kinds of presentations are occurring, the chair of the special committee will be making them to the board. It's helpful to have the legal and financial advisors that have been helping out the special committee be available if they're not actually present at that board meeting. You know, so that if the board has questions, you know, about the report, interim or final, you know, they're asking them of the chair, but they can also have direct access to those legal and financial advisors and have a better understanding of sort of the information that's underlying the special committee's recommendations. In terms of the relationship with management, it really sort of depends on the circumstances, but, you know, I see two sort of roles with management. The first is the special committee is going to need information. It'll have to provide information, you know, to its legal advisors, to the financial advisors. That might be something like projections, whatever it is. And so they're the conduit and you know, should be involved in the process of getting that information from management and feeding it out to the advisors. So there's that piece of it. And then I think, you know, the second piece of it is to the extent that there's an ongoing negotiation, this is a transaction, depending on the nature of the mandate the special committee has, they'll either be supervising those negotiations or they might even be actively involved in the negotiations. And they're going to be doing that side by side with management in all likelihood, as opposed to, you know, the board more fully doing that. So those are the two circumstances that I really sort of see the special committee working closely with management.
Okay, thank you, Kathleen. So Cam, for the Rocky Mountain Special Committee, the board had a mix of independent directors, as you said, and insider directors. So how did you handle the communication between the special committee members, number one, the special committee and the board, number two, and the special committee and management, number three?
Yeah, thanks, Greg. I'll touch on those dimensions of communication. So firstly, with respect to call it the intra-committee, the special committee member communication, I mean, there were simple things like just move the email platform outside of the company's domain, you know, just common sense stuff. We did have all special committee members included in virtually all communications regarding our mandate. This included work with advisors and all those elements. I mean, you could argue that, well, less should always be more, but in our case, you know, more was more. With the pace of play, et cetera, we wanted to keep everybody up to speed. So I would say we had a very fulsome communication loop and process going within the committee. And, you know, with the exceptional professional conduct displayed by our committee and our members, we had no worries about things like confidentiality and conflict of interest. But that said, we did discuss those things often and in a variety of different contexts, both generally and in fact specific circumstances. And again, as we've all come to live and breathe with, the virtual meeting platforms, they actually proved invaluable in the process, at least by my estimation. I can't imagine trying to bolt in even a third of our meetings as physical meetings that we had. And I think we used every virtual meeting platform available. We've talked already about our many meetings over the course of the 3 special committee iterations. So we found that to be very efficient and something that I think, as we all know, will likely continue into the future. With respect to communication with management, certain members of management were involved in the transaction, so we rightly fenced them off from all communication regarding the deal, and we had a communication protocol with members of management not involved in the deal. Again, an obvious step, but we made sure this process was agreed, it was documented, and it was followed. So many special committee matters involved communication from our legal counsel, Greg and his team, to company legal counsel, and virtually all communication between management and the special committee involved legal counsel and or myself as chair. So just again, we've used the term robust a number of times, but just a robust communication protocol all around, and confidentiality was separately and really importantly emphasized with non-involved management, obviously. My final item, communication with board members not on the special committee or not involved in the deal. In our situation, we did have one board member who was not involved in the final iteration of the go private bid, nor was he on the special committee. So again, we set a policy and followed a process to keep this other member of the board properly updated on all matters, with appropriate confidentiality undertakings again, and with proper legal advice. So whether we had 1 or 2 or 3 or other members of the board who weren't on the special committee, that would certainly be a recommendation. So my conclusion on communication, the takeaway here is to think long and hard about the ways and means by which communication will be conducted during the committee process, and it's just apply every general rule of good communication protocols, and then critically assess what additional protocols you might need specifically in the circumstances. And again, back to documenting policies and processes, keep records, and obviously stick to those communication policies once you've set them.
Okay, thank you very much, Cam. So Kathleen and Cindy, why don't you both kind of respond to this next question? So what's the role of the advisors to a special committee, and who could those advisors be?
Sure, thanks, Greg. And I think this is there's at least one question that's come up on the chat, and we can talk a little bit about answering that one. It's how unlikely is it for the special committee to retain the same outside counsel as that of the corporation? So first of all, there's no legal requirement for a special committee to seek financial, legal, or other advice, just generally speaking. But obviously failing to do so can increase the risk that the committee is not adequately informed and therefore not able to properly fulfill its mandate. So, we typically see special committees getting both financial and legal advice. And if there's some other kind of unique aspect to the matter that the committee is looking at, then you could see other advisors becoming involved as well. Perhaps accountants, on the mining side or oil and gas side, scientists. So there's other areas. What you're looking for is expert advice that can help the special committee formulate its views and its recommendations to the board, and they should take an active role in helping the special committee. What you're looking for, and this kind of goes to this question, is you really should be looking as a special committee member for impartial advice and guidance, so that you can, as a special committee, satisfy your mandate and comply with your duties and obligations. And I guess the issue is certainly seen circumstances where legal counsel to the company, to the board, ends up effectively being legal counsel to the special committee. But you have to start to ask questions about the influence and the independence of that counsel. Same thing holds true with a financial advisor, whether that really is appropriate in the circumstances. So I think, if the company has the money, I think the preference is to go with the independence. Absolutely. We do see, some more junior issuers struggling with hiring extra counsel, extra financial advisors. And sometimes in those circumstances, they do end up using the same counsel and financial advisors. But but for some other reasons that Cindy and I are going to discuss later, even on the financial advisor side of things, that can be challenging as well. So really, in a going private transaction, special committees tend to retain both outside independent legal and financial advisors, just due to the complexity of the transaction and the potential conflicts of interest.
Yeah, and I think just touching a bit on what Kathleen, said, there is a reluctance on sort of not really on the larger transactions, but on the smaller transactions to, no one wants to have more lawyers, more fees going out the door. And I've acted, and so has Kathleen, on all sides of sort of, the M&A fence where you're acting for various parties. And so it's great because you have, that additional insight in those roles. But, my role as counsel to a special committee, and Kathleen has, alluded to this, is very different than my role when I'm acting for the issuer, whether it's the target or the acquirer. And so to the extent special committees are adverse to hiring, outside counsel, and I always recommend it because I think it's better for, the company, it's better for the process if they can afford it, and there's lots of, you don't have to hire one of the top firms. There's a lot of very skilled people that, will provide you with the guidance that you need on these transactions. But I think that's just something you need to be aware of, that if you don't have your separate counsel, you're probably not doing the committee a service just by relying on the issuer's counsel, because they will be focused on different aspects of the transaction than a specific counsel to the special committee would be.
Okay, good stuff. So Cam, I'll ask you, as the prior special committee chair, how important to you are the advisors to the special committee for your transaction?
Yeah, thanks, Greg. Certainly critical to our process. I've worked in my day job as an advisor for over 40 years, so I think I do have a bit of a sense of what works when using advisors. And I like to frame it as a combination of expertise, experience, and then the value add that is delivered. At the end of the day, that's what it has to be, is you need value out of advisors. And for me, expertise means an advisor possesses knowledge. So often on technical things like a regulatory framework, tax law, industry expertise, for example. And then experience to me means the advisor has used their knowledge multiple times and has a good practical sense of application of their expertise. So the value then simply becomes the difference between the best possible outcome with the application of that quality expertise and experience and the worst possible outcome without it. So in the end, competent, responsive advisors, it's absolutely a must. And just to touch on the last point, I think from Cindy there, we were well served to have independent counsel for the special committee, different from counsel of record, corporate counsel. So it wasn't, it just was very valuable to have that, because different issues and different perspectives come up. So in our case, as has been said, we had Gowling's as legal counsel for the special committee. And just a quick example of their responsiveness and how value was added was when we came across a precedent transaction. It was similar to ours in some respects, and we wanted some pretty deep insights into that. And within 24 hours, we had a detailed workup on that situation from Gowling. So it just allowed us to carry on without missing a beat and be able to integrate that into our thinking and planning. We had RBC as our financial advisor, and they provided strategic advice as well as fairness opinion. And this was something discussed at length at the start of our process. Do we need a financial advisor? Again, in the end, very glad we did, and they added the value as well. An example of their proficiency, we wanted insight into how a certain aspect of go private transactions had been handled historically based on matters of public record. So within a day, we had a detailed workup of every transaction similar to ours over the last 10 years. So, you need certain amount of horsepower and depth to be able to do that kind of thing. And that's just, those are examples of the benefits we had from both legal and financial. An independent evaluator is a must, obviously. 61101 provided a fairness opinion, and we got great service from Deloitte, who did the formal evaluation and provided the fairness opinion. With our legal team at Gowling's and our financial advisory team at RBC, we had that right mix of professionals, some team members that could advise effectively on the back to the art of the deal, those that had been involved in lots of deals and had strategy, and certainly those that could advise on the science of the deal, making sure we stayed out of the ditch on all of the technical issues, et cetera. And so we made very good use of both of those skill sets within our advisors. Again, as to value, well, the difference between the best possible outcome with the application of their expertise and experience, it exceeded the worst possible outcome without it by a very wide margin, I would say.
Thank you very much, Cam. So Kathleen and Cindy, we touched on a little bit, and that's the fairness opinion. It's often a very important document provided by a special committee advisors. So can you comment on the fairness opinions? And Cindy, maybe I'll ask you to go first.
Sure. Well, this is really a very evolving topic. Yeah, it's very relevant to special committees and other individuals that are parties to M&A transactions. You know, I do a lot of work as counsel to the financial advisor to either a special committee or to an issuer, and the fairness opinions are now have become sort of a very debated, I guess, matter. So for special committees, it's really a determination of what to get and who to get it from. And you know, neither 61101, so securities legislation, or corporate law requires a transaction to be accompanied by a fairness opinion. And therefore it's really the responsibility of the board and the special committee to determine whether a fairness opinion is necessary to assist in making the recommendation to security holders on a proposed transaction. You know, it's very customary that boards obtain fairness opinions to help them demonstrate that they've satisfied their fiduciary duties in approving a transaction, and certainly in a court approved transaction such as a plan of arrangement, it is expected by the court to see a fairness opinion. And if you walk into court without a fairness opinion, your transaction is subject to scrutiny. In addition to a fairness opinion to the board, I think we've previously alluded to that we're now really seeing second fairness opinions being prepared by independent financial advisors addressed to the special committee. But I think what's important to remember is that the opinions offered by advisors are not a substitute for a committee's own considered judgment. Fairness opinion speaks to the fairness of a transaction from a financial point of view to the shareholders of the company. It's not a substitute, or the committee members can't substitute their own judgment as to what's in the best interest of the issuer and the minority shareholders, just in reliance on that fairness opinion. They have to bring their own experience, knowledge of the issuer to bear, and they have to look at the underlying assumptions and methodologies used in those fairness opinions. So Kathleen, why don't you talk a little bit about some of the, relevant case law affecting fairness opinions? Sure,
thanks, Cindy. So there have been a number of recent cases over the past few years. You'll have heard about Interoil, Sherritt, and more recently Canopy Rivers, that have sort of had to deal with situations regarding fairness opinions. And there's really two areas of evolution that we see. I mean, the first has to do with the situation where you've got a target company and the financial advisor is going to get a fee that is contingent on the completion of the transaction. So it's a success fee. And if you really think about that, they're giving an opinion that a transaction's fair. That fairness opinion is being taken into account by the special committee on its recommendation, by the board, and generally speaking, then by the investors. And so, it's a bit challenging. You can see the risk for conflict there. Certainly it's a perceived conflict, So what we are seeing more and more is in those types of circumstances where the financial advisor has the success fee, that the best idea is for the target board to go get a second fairness opinion from an advisor who's only entitled to a fixed fee, something that's not contingent on the completion of the transaction. So we do see that sort of evolving as a result of some of the decisions from the courts. And then the other area is, the typical sort of more old-fashioned fairness opinion was just simply a statement, that it's fair from a financial point of view to the applicable security holders. And there isn't, there hasn't been a lot of analysis or reasoning sort of provided in the sort of what we call the short form fairness opinions. And so there is definitely a trend evolving towards longer form opinions, where you start to see a little bit more of the financial analysis. And the CSA staff have actually spoken to the issue of fairness opinions in the staff notice that we mentioned earlier. Obviously, this is in the context of a material conflict of interest transaction. But what they're looking to see in the disclosure document is disclosure around the compensation arrangement, including whether there is a flat fee, a fee contingent on delivery of the opinion, or a fee contingent on the successful completion of the transaction. They want to see the board or the special committee explaining how they took into account that compensation arrangement when considering the advice provided. Again, sort of thinking about the conflict there, potentially. They want to understand in the disclosure any other relationships between the financial advisor and the issuer, or any interested party. Again, this goes to the question around independence. I mean, some companies have longstanding relationships with financial advisors. And, is that the party to advise in this circumstance, or should somebody fresh to the situation be providing an opinion? They want a clear summary, and this is what you're starting to see in these longer form opinions of the methodology, the information that was reviewed, the analysis, including applicable financial metrics, not just some narrative description. Just enough information for the reader to understand how the opinion was arrived at. And you need to, the advisors are going to have to balance that, and in the disclosure you're going to balance that, because you don't want to overwhelm the investors with too much information. But and finally, they want to see an explanation on how the board and the special committee considered the fairness opinion in arriving at the recommendation for the transaction.
Okay, thanks, Kathleen. So Cindy, why don't you we'll move to our last topic, and what are a few key governance tips and practices applicable, do you think, to all special committees?
Sure, thanks, Greg. And I know we're running out of time. I'm going to go through these quickly, but we've really touched on a lot of these throughout the discussion. I mean, certainly there is a lot of lessons learned through the decisions of regulators and the courts, as well as our own experience, which are the best practices special committees and boards can put in place to protect the integrity of their decisions. So, and these are to a large extent in the transactional context, but they can be drawn into the other areas that we've talked about. So first, establish a special committee early in the process. Early involvement of the special committee provides the greatest protection of the board, and appropriate steps need to be taken as soon as possible to manage conflicts. And this includes the early establishment of a special committee before important decisions are made and rates are given up. And again, in the CSE notice 61302, staff have identified many occasions where special committees were formed after a proposed transaction had been substantially negotiated. So evidence that the special committee was playing an active role in the negotiations from the outset is critical. Again, going back to our mandate, this is number 2, give the special committee broad authority. The board should establish and approve a mandate for the committee that's sufficiently broad to give it the authority to exercise its judgment and make decisions and provide meaningful recommendations. If it's too narrow or constrained, it's likely to face criticism from the regulators or other stakeholders. And this was, very much an issue at the forefront in the Magna International case. The OSC was highly critical of the process undertaken by the board and noted that the special committee's mandate was too narrow. It was only charged with reviewing and considering the proposal on the table. It didn't have authority to consider whether alternatives were available or better. And so that gets to tip number 3, don't limit yourself to one course of action. If you're a special committee member, seek the advice you need from your advisors to understand what are the reasonable alternatives, including maintaining the status quo to maximize shareholder value. 4, this seems obvious, but obtain and diligently review all the relevant information and participate in the decision. You have to demonstrate as a member of a committee that you have all the information. You can't just rely exclusively on the information to be provided from management of the company as a matter of course. And, as Cam alluded to this, you have to review the information, and anyone who's been involved in a public M&A transaction understands how voluminous the paper can be and how complicated the documentation can be. But, it is prudent for you to go through those documents and, to certainly understand them. And you should insist that you be given the proper amount of time to review the information. And again, sometimes that's so challenging in the M&A context because the deals are public M&A, because the deals are fast and furious. But if there's no emergency, take a reasonable time for deliberations and insist that you're provided with the documentation that you need to review well in advance of making decisions on it. 5, we've talked about this, retain expert advisors. I always, like I said, suggest that when I'm acting for an issuer that the special committee retain independent advisors, legal and financial advisors. And then 6, document the process. And this is so important because, and again, it's one of those sort of aggravating things when you're in the middle of these deals to have to prepare minutes or reports, as Kathleen said, but those really should be prepared, and they should be prepared in real time. They rarely are, but they should be. And they need to be sufficiently detailed, taking into account privilege, to demonstrate that the committee's fulfilled its mandate and to summarize the advice that it's received. And, Kathleen alluded to this, this is the OSC's reviewing these transactions in real time. And, we have been in situations where we have filed information circulars and the next day we're getting requests from the OSC to see things like the mandate and the minutes. And if you're all of a sudden, as Cam said, you've had, 10 meetings before you even came to a decision and the minutes are sort of still in draft, that doesn't look well on the board, and it's a bit of a scrambling exercise to put it together.
Okay, so I know we're almost out of time here, but Cam, from your experience as the previous chair of a special committee, any best practice tips that you could recommend?
Yeah, great. I'll do a couple of rapid fire here. Certainly agree with the early assessment of the need for the committee. Better to have a false start than a late one. Checkoff item, D&O insurance, make sure that that's in place. It should be, but you don't want to be saying, oh, we never thought of that. I want to reiterate what Cindy just said on record keeping. If you're going to get into a situation where you need a circular, your minutes will be, the information will be a big part of that. We implemented a process to monitor stock trading activity, obviously pre-announcement, and that was critically important. Totally endorsed the broad mandate for a special committee. We made good use of that in our situation. And then as a chair, really this applies to any chair activity, but you need to be assertive, and certainly more assertive than less in the case of the special.
Hi, did we lose Cam there for a bit?
Oh, I'm not sure. Have you got me?
Okay, got you, Cam.
Okay. I was just saying, as chair, you need to err on the side of being more assertive than less. Don't be afraid to call the question when your discussion on alternatives has reached the point of diminishing returns. It's the old round table. Don't take silence as agreement. Make sure you elicit opinions from the folks that are populating your special committee. And then constantly revisit that mandate. It's been mentioned. Why are we here? What do we need to do? And how are we going to do it? Anchor yourself back to those thoughts if you lose your way.
Okay, thanks. And I'm just going to end with just have each of you just give a concluding comment you'd like to share about a special committee. So Cam, I'll just start with you. As you said, a quick snapper to end on. Yeah,
sure. Thanks, Greg. So certainly a special committee is probably as far from routine governance as you can get. So recognize it as that. Special committee members drawing deeply on analysis and judgment skills. It's a great example of a critical team process. It's not quite like landing the rover on Mars, even though it'll probably feel like that at times. And you can't afford any weak links in your overall team or your processes, because that will be the ceiling for your success. And my final two comments. Number one is, I wish I had this kind of a session before we started, which was great. And secondly, I'll end where I started. Recognize the different elements of the process, the art of the deal, the science of the deal, and act accordingly. So thanks, everyone. I wish you good luck with your future special committee involvements, whatever those may be.
Thank you very much, Cam. Kathleen, a quick snapper for the end.
Sure. I guess I would just like to comment that, boards are facing more complex and sensitive issues, and so I think special committees are really well positioned to help boards with these types of issues. I think they're becoming more common, not just for M&A. And really for the reasons that we've talked about, I think they can be more efficient and timely. There's a level of expertise that you can bring to a special committee. And I'll just give a recent example that I've been involved in is where a board had to respond to a cybersecurity attack. Again, having that dedication of resources and timeliness required to respond to a ransomware request. For example, that can also be an example of why you would want to strike a special committee. So I know we've talked a lot about M&A, which is what Cindy and I do a lot of, but I would just say that special committees, I think, are going to be, we're going to have more and more.
Thank you. And Cindy, you get to have the privilege of giving the last word. So any quick snapper for you for the end?
I don't know if I can do a snapper, but anyways, we've touched on this. Special committees serve an absolute vital function, and they really protect the integrity of a board's decision-making process.
4 minutes over.
Not sure. So I think somebody's not on mute.
That's Bob.
But that's fine. Remember the tips, we've given, those will really assist, your special committee functioning the way that it should. And again, remember, process is paramount, and it's process and substance, not form.
Okay, thank you very much. Any of you that have questions, I know there's a couple, please feel free. We're out of time, but feel free to reach out to any of us here at Gowling, Cindy, myself, or Kathleen, or Cam. Want to thank Cindy and Kathleen for their time and effort, and especially thank Cam for helping participate. Cam, you brought some huge value to this session for the practical advice. So want to thank everybody who participated and for your attendance, and hope you all have a wonderful day and stay safe. Thank you very much.
Thanks.